Welcome. Patent to Venture is your path from idea to venture. Some of the most common questions I get have to do with how long a patent is valid for. And the short answer to that is a utility patent is good for 20 years from the date that the application is filed. But unfortunately, there are several things that complicate this, and so sometimes it takes a little bit of study to find out exactly whether or not a patent is still valid or not. For many patents, it's really simple to find out what the filing date is for your patent application. It's printed right on the front page of the patent. If that's the first application that you filed, that filing date will be the filing date for purposes of figuring out your 20-year patent term. It's very common, however, for multiple patents to be filed. U.S. utility applications, provisional applications, foreign applications. There are a whole bunch of different filings that can be made that might be chained together, claiming priority to each other. And in that case, the filing date may take a little bit of an analysis. It's the first U.S. non-provisional patent application that the filing date of that patent is the filing date that you calculate the term from. So for example, if you file a first patent application and then later you file another patent application and the second one claims priority to the first one, if the first one is a U.S. non-provisional utility application, then the first patent filing date will be the one that you use. This isn't the same though, however, for provisionals and for foreign applications. Provisional and foreign applications can effectively add a year to your patent term because that 1 year of patent pending does not count towards your 20 years. So when you're looking into a patent to see how long the patent's going to be good for, you'll see the filing date for that existing application, and then you can also see on that first page of the patent any references to earlier applications. And if there is an earlier U.S. non-provisional application, that's the filing date you'd use, not the filing date of the later application. Another factor that can complicate things is if they initially file the application as a provisional application. A provisional is a temporary 1 year filing that's very frequently used when technologies are evolving quickly and you want to file quickly, but you haven't had time to finish the full application, or if you have, maybe you haven't worked out some of the technical details. So if you file a provisional, you can wait up to a year before filing the utility, and that year doesn't count towards your 20-year patent term. So if you start by filing a provisional and wait the full year, you actually in the end up with a 21-year patent term. But unfortunately, the provisional is not examined, so there is a delay in actually getting the patent granted. Patent term extensions in the event that there's, for example, delays during the prosecution of the patent application. So if you are dealing with a patent that's approaching expiration, you'll need to check and calculate whether or not there were any patent term extensions that would apply, and it may last for a little while beyond the 20-year term. Now, I know a lot of people are watching this video because they're concerned that they might be infringing an existing patent. A lot of times people are concerned with the patent term when they find a patent that's similar and they want to know whether there's a chance they might infringe. At the end of this video, I'm going to include a bonus feature where I'm going to talk about how to review claims and better understand whether you might infringe an existing patent. So wait till the end if you're interested. First, it's necessary to file maintenance fees at 3 points during the life of the patent. And if those maintenance fees aren't paid, then the patent will expire. These are due at 3.5, 7.5, and 11.5 years after the registration of the patent. So if you own a patent, you'll need to make sure to docket and pay those maintenance fees. Usually your attorney will remind you when those deadlines approach. If you're trying to avoid infringing a patent that within 20 years, you can check online at the USPTO to see if the patent still is valid or whether it's expired for not paying maintenance fees. Patent maintenance fees change fairly frequently, so you'll need to check online the patent fee schedule to find out what the maintenance fees are at that time. If you simply Google patent fees, the USPTO fee schedule will be one of the first options, and you can click on that and scroll down to the maintenance fee section. It'll give you the most current fees. Currently, the first maintenance fee is $860, the second is $1,616, and the third is $3,312. These fees are for small entities, which is what most people will qualify as. If you're particularly low income, you may qualify as micro entity, where you can pay half price fees. Larger companies are going to pay double as large entities. If you inadvertently miss the filing deadline for your maintenance fees, you can pay up to 6 months late with the payment of a small surcharge. That surcharge is currently $216 for a small entity applicant. If the patent maintenance fees are not paid within that 6-month grace period, the patent will expire and will no longer be valid. Now, it is possible for a patent owner to revive a patent which is expired accidentally, either through unavoidable or unintended errors, but this requires a substantial extra fee. And if a competitor starts making a competing product while the patent has expired, and if the patent owner then revives the application, that competitor may acquire what's called intervening rights, where even though the patent is revived and valid again, they are able to continue making the product that they started while it was abandoned. This is known as intervening rights, and you really want to make sure not to allow your patents to go abandoned, or it may open the door for competitors to start offering competing products even while your patent is still valid. It is possible, however, for you to assert that patent against any other competitors. It's only the ones who started their competition while the patent was expired that get these intervening rights. Now, I know a lot of people trying to understand patent term are interested because they found a patent that's similar to one of their products, and they're concerned that they might infringe this patent. Obviously, the first step is to determine whether that patent is still valid, and that's obviously what the first part of the video is for. However, if the patent is valid, you're going to want to try to get an understanding about whether this is legitimately something you might infringe or whether it's not a problem. Now, to determine whether you infringe a specific patent, you look at the very end of the patent. The very last section is a section called the claims. This starts out with a preamble that says, I claim or we claim, and then it's going to start with what's known as an independent claim number 1. And these independent claims are the ones that you want to look at. These are the ones that you might potentially infringe. There are other claims, like in this case, claim 2, where they specifically reference an earlier claim. So this one says the method of claim 1. That a dependent claim you can pretty much ignore for purposes of infringement. It is important, but it's not. The independent claims are the ones that you really need to look at. And what this claim 1, and sometimes there'll be other independent claims as well, but you can really get a pretty good idea looking at claim 1. And the claim lists all of the limitations that are necessary to infringe that patent. And so if you look at that claim 1 and the other independent claims, and if it specifically lists requirements that your product doesn't have, then you most likely don't infringe. And in fact, sometimes the claims will actually be very different than a lot of the rest of the application. So I've seen patents that have a lot of drawings for one particular product, but then the claims are directed at figure 15 or something like that. And when you can figure that out, you can quickly see that you don't infringe. So if you have a patent that you think is of concern, look at claim 1. Just read through it. It's to some extent you can do it just plain English, and if it starts talking about things that your product doesn't include, you're most likely going to be safe. But this goes with a big caveat. This is very, very technical, difficult. The final analysis can be very complicated, especially when you are considering obviousness and doctrine of equivalence and a lot of these legal theories. And a lot of times the terms may not necessarily mean what you think that they do. So just use this as a preliminary review so that you can get a better idea about where you stand. If you legitimately are concerned about infringing a patent, you definitely need to talk to a patent attorney and have them give you an analysis. And you may potentially be able to ask them specifically, this appears to require certain elements that mine doesn't have. It may be fairly easy for them to see that there's no infringement. I hope that helped. And if you have any questions, feel free to send me an email or schedule a phone consultation. If you enjoyed the video, please be sure to like and subscribe.